University
Dear
Law,
President
Faculty of
of the
Law,
Turkish
Dean.
Personal Data Protection Authority, dear President of the Protection Authority of the Turkish Republic of Northern Cyprus, dear Rector of Istanbul University, dear Rector of Turkish German University, dear guests and participants. Besonders our guests, Professor Ulrich Kelber, Marit Hansen, Wenceslav Karadio, herzlich willkommen. It's a great pleasure to welcome you in the first International Congress on Personal Data Protection. Thank you to each and every one of you for being here with us today. Let me introduce you the three speakers in the first session. Professor Ulrich Kelber is the Federal Commissioner for Data Protection and Freedom of Information of Germany. His presentation is regarding artificial intelligence. Marit Hansen is the Data Protection Commissioner, Schleswig-Holstein, whose topic is surveillance at workplace. Do employees have a right to data protection? And Wenceslav Karadio is Bulgaria's Commissioner for Data Protection, Personal Data Protection, and Vice Chairman of the European Data Protection Board. His presentation is regarding European Data Protection Board. In the first session, each speaker has at about 20 minutes. For first speaker is Mr. Professor Kelber. Stage is yours.
Begun to fundamentally change our lives. Disruptive change is predicted, like the transition to the machine age based on fossil fuels in the 18th and 19th century. So something really big is coming up. We're at the beginning of that transformation. So many potential applications are still in their infancy. I think we are well advised to take a nuanced view of the opportunities and risks of that development. The data protection authorities in particular should help to support wise recommendations for action in the future. Our goal must be to promote innovation while ensuring the best possible data protection. And even though there are not a few saying this is impossible, I keep on telling them, yes, we can, and we will. So AI systems can affect the freedoms and rights of natural persons in many ways. This is because AI presupposes the usability of a lot of personalized data. So, for example, enormous amounts of learning data are required, from which the actual problem-solving algorithm is generated. In many areas, we are talking about classic big data application. While AI will fundamentally change our lives, it's an important issue in many international formats these days. It would take much more time than the time of these impulse if I would present all of these initiatives. That's why I would like to focus on some specific examples. Before I set out the world's first draft legal framework for AI presented by the European Commission, I will present the work done by data protection authorities. I would like to begin with the Global Privacy Assembly, the GPA. The GPA is a premier global forum for data protection and privacy authorities. So the Assembly seeks to provide leadership at international level in data protection and privacy. It does this by connecting the efforts of more than 130 data protection and privacy authorities from across the globe. Turkey will host the annual conference of the GPI next year. And AI is an ongoing work for the GPA. At the 40th conference in 2018, the GPA endorsed guiding principles as its core values to preserve human rights in the development of AI. In 2020, the Assembly adopted a resolution on accountability in the development and use of AI. Recently, I took part in the roundtable of G7 data protection and privacy authorities. In this format, the authorities of the G7 member countries discussed opportunities for closer collaboration. Well, you've seen that topics like free flow of data with trust is a topic on the G7 table. At this roundtable, we agreed that data protection and privacy authority must play a leading role in the governance of AI, which is built on personalized data. They should constructively influence the development of AI systems and create a framework that safeguards human rights, democracy, the common good, and individual freedoms while creating room for innovation and progress. Red lines are needed for AI systems which are not compatible with our values and fundamental rights. To fulfill this task, data protection and privacy authorities need sufficient human and material resources. The EDPB, represented by my colleague, and the International Working Group on Data Protection in Technology, the so-called Berlin Group, are working on guidelines for the areas of biometric identification and devices with audio recognition. The work done in the international formats leads to recommendations for action. So what are these recommendations in the context of AI? In my view, we have a clear consensus as data protection authorities on minimum requirements to be met by AI systems. First, AI must not turn human into objects. So we need to think very fundamentally about which AI application should cross our red lines and be banned as a matter of principle. Second, AI has a tendency to be intransparent. However, we need a high degree of transparency and traceability of the results and processes of machine-controlled decisions. AI must be made as transparent and comprehensible and explainable as possible. What do I mean by this? So we need transparency about how the decision-making of the AI system works. This transparency is also essential for trust in AI, and however, it is anything but trivial to establish this transparency in the first place. Simply disclosing program codes and training data would fall short. Those affected by AI are generally not IT specialists, and even experts would be overwhelmed by the technical complexity of some AI systems. What we need in any case is an explanatory statement on AI systems to make the respective mode of operation comprehensible to the general public. So this statement is important because otherwise the data subject will hardly be in a position to consent to the corresponding processing. Without it, they would not even know what they were actually consenting to. Third, AI, of course, must avoid discrimination. As a matter of principle, data subjects have the right to intervene, explain their position, and challenge a decision, even when AI systems are used. The final decision should therefore always be left to a human being, and corrections have to be possible. This human corrective is indispensable as a guarantee for fair AI. This applies in any case if it is accompanied by impairments for those affected. It's clear that AI is fallible. The reason for this is simple. Errors may have crept into during programming or designing of the system or designing of the optimization task. Another reason that the results of an AI system depends to a large extent on how it was trained. So what feedback and decision paths were learned here. If the system was trained with biased data, this will be also reflected in its decisions. Unfortunately, these errors and discriminations based on them are often not recognizable in advance. So neutral and thus fair decisions by algorithms simply do not exist and probably never will. For as long as technology is programmed or designed by humans and based on man-made data sets, it will be subjectively colored. We are well advised not to rely willingly only on the results of AI. The aspect of effective control, that also plays an important role in this respect. Fourth, the data protection principles of purpose limitation, purpose binding, and data minimization naturally also apply to AI. Here in particular, it makes sense to use data protection-friendly technologies. Often, for example, the processing of completely anonymized data can be sufficient to achieve the intent purposes. And fifth, in order to adequately accompany the development of AI, the data protection authorities need sufficient human and material resources in governing this process. The European Commission presented the world's first draft legal framework for AI in April this year. So the draft law is intended to promote the development of AI, ensure a high level of protection for public interest, and create a base of trust for AI systems. The requirements are to apply alongside data protection regulations. Included are obligations for providers, distributors, importers, and users of AI systems. The legal requirements shall apply to every placing on the market, commissioning, and every type of use of AI systems in the European Union. The draft AI regulation is designed around the risk-based approach, which regulatory requirements of varying degrees of stringency. AI with unacceptable risk will be prohibited. For example, social scoring by public authorities, or on their behalf, exploitation of children's vulnerability, or with exceptions, real-time biometric remote identification for law enforcement purposes. AI applications with such high risk have to comply with certain quality requirements. This includes data quality, accuracy, robustness of the AI system, obligations for documentation, traceability, transparency, and ensuring human oversight. Before being placed on the EU market, such systems must also undergo a conformity assessment to demonstrate that AI systems meet the requirement of that regulation. High-risk AI systems are defined in an annex by way of example. So AI systems to decide on the accessibility and use of basic private and public services and benefits are qualified as high-risk AI, for example. But even low-risk AI systems must in principle be designed in such a way that natural persons are informed that they are interacting with an AI system so that there is transparency in this respect. While the EU data protection authorities, in their opinion on that draft regulation, have welcomed the risk-based regulatory approach in general, they have also expressed their concerns about missing red lines such for all forms of social scoring based on AI, for example, for private companies. They've also called for a general ban on any use of AI for automated recognition of human features in publicly accessible space and demand leading and oversight competences in this new regulated field of digitalization. To sum it up, data protection authorities are not at all against technological evolution. We are pro-digitization. We clearly see the potential of AI, especially if embedded in a value-oriented digitization. The data protection authorities, among others, are helping to shape a valuable digital future for everyone. So thank you for the attention.
Vielen Dank, Herr Professor. Second speaker is Ms. Marit Hansen. Now it's your turn. You have 20 minutes.
Thank you very much. So right now I'm sharing my presentation. You should see the first slide. If not, please intervene. It's about surveillance at the workplace. Do employees have a right to data protection? And it's not totally unrelated to what we heard before, because artificial intelligence technologies also play a role when it comes to surveillance at the workplace. And this topic is also not chosen by chance. It's something which came up or will in the future come up even more when it comes to digitization, for example, because of further home office situations, homeschooling situations, so everything which the pandemics demands. You should see now the second slide. If not, please again tell me. Here only that you know what I'm talking, where I'm talking from. I'm here right now in Kiel. And Kiel is in the northern part of Germany, named Schleswig-Holstein. So this is my territory. And today I'd like to give you some insight in surveillance at the workplace. And you see at the left the picture where the employer has the potential possibility to look always, each minute, 24/7, what the employee is doing. And you see also that there is a change or an imbalance in power. And this is something which we don't only find in the situation of employee data protection, but this is fundamental effect where we need data protection and data protection commissioners. You see my structure. I'd like to talk about surveillance, give some examples. Then the rights of the employees is stemming from the General Data Protection Regulation. Some idea on how to balance rights and interests, tell you about current trends and give you a solution. So what is now done? I'm on page 4 now, surveillance, how is it done? And we see very much video surveillance, even in restrooms, in some internal areas where the employees are, and this in Germany at least is clearly off limits. And I see in most countries that this is also something where employees do not expect it and also are, well, not embracing the idea of being surveilled 24/7 all the time. This can also happen with audio, for example, taping the phones to check whether everything is all right, whether the persons perhaps are polite with the customers. And sometimes it's combined with biometrics, another very basic technology, for example, facial recognition for video surveillance. Meanwhile, there are also other sensors that play a role, can be in the workplace, near the computer, in every area of the room, which, by the way, has been tried out in the COVID scenarios to see how far or how near people are and whether they comply with the organization rules, but also whether they are at their workplace at all. So whether they have left or have not appeared, so that the sensors, these sensors can also detect whether a person is there and breathing and how many are in the room. It can also be done by wearables like a fitness watch and with some body sensor data, also, for example, to see whether a person has slept well, which may be very nice to be sure of that, but is it really a question for the employer to know about the sleeping habits of the employees? In general, not. The computer usage is also very much used for surveillance areas. The key logging, so really being able to read every stroked key, the mouse movements. Meanwhile, there are some defense software tools where the mouse is always moving at the employee's computer because the employee knows that without a mouse movement, software may think that the person is not working. So meanwhile, there's defense technology. Screen captures where the employer can see every minute what is happening on your screen, browser app monitoring, access logs, interpretation, something with logistics, geolocation tracking, or background checks, who you are, what you are doing at social media at a private person. And it can be done for general task performance, but meanwhile also, and there we also come in the area of artificial intelligence about emotional analysis. Is the employee perhaps disgruntled? Is it somebody who is perhaps not working in the same motivation we expect from our employees? Is it somebody who is polite or not? So this is not a perfect analysis, but meanwhile, some software tools offer that they give you a score and that you may have to argue when you think this has been an unfair treatment. Attention tracking, occupancy tracking, I told you about it. And why is it done? It's not necessarily something in a bad motivation of the employer. It's not necessarily spyware. It can be done for safety and security of the employees. And of course, also the employer has some necessary demands for protecting the own assets. That can be data protection, for example. There can be other resources or the reputation of the organization. The monitoring of the employees' actions or behavior can be because finding out whether they comply with the policies about productivity or also about preventing health or safety problems. So really something where it's maybe good for the employees themselves. It can also be done for gathering data, for optimizing business processes and for optimizing human resources, which again is something now which may lead to who to fire, who to hire. And here you see at the examples, there is somewhere a line between what is lawful or unlawful. And it's not totally clear where it is. In most jurisdiction, it's very, very open for at least the issue of new technologies. And also some methods may be lawful, but still unwise. Only as an example, I found a Walmart patent. So Walmart, a big company selling goods, and it's called listening at the back end, I think, at the cashiers. It can listen in, it's only a listening device by many sensors, seeing what is then in the carts. It detects rustling bags and sees how people are crossing the cashiers, how many they are, whether the bags that are packed are full or not. And so each sound can be detected, and it's in the general result. Its objective is to determine a performance metric for the employee. Also listening in what are the keywords that the person is perhaps not so nice to the customers, or he or she is too nice to the customers. What about the tone, the vocabulary that is used, and everything is here in the patent, where in principle it's about a performance metric for the employee. And well, I think it's an interesting idea to do those patents. Not always patents pave the way for a real future. Sometimes this will never happen, but very often you can understand how companies are, well, thinking or planning to go ahead. There are two studies I'd like to draw your attention to. One from the US on the workplace surveillance from August this year. It's in English. And one German, sorry, Austrian study. But it's very nice, and especially if you see here on the right side, the picture in the middle of the study, I've zoomed in. This is from Wolfi Crystal. He's very, well, he digs into all the stuff, and you see here as a visualization kind of dashboard for the employer to see on the left side, einstellen, hire, right, feuern, the firing of people, and in the middle, always some stars, some scores attached to people, whether they comply, whether they are productive, where they are low or top performers. And in principle, well, this is possible, and there are many providers offering software tools or other tool sensors to help with that. What about the rights? Of course, there are rights, and the main message is for the European Union, the application of the GDPR is out of question. There's a specific article, it's the Article 88, and this is about what are the member states are about. Can they do more in the field of general data protection for employees, or perhaps are there exceptions? And if you read this article, it's clear you can be more specific as a member state to ensure the protection, but it's not about putting in some holes in the protection. It's the other way around. And the collective agreements may be also of interest. This is about staff councils, especially, sometimes also trade unions, who can represent the rights of all employees, not only the specific, very perhaps small employee with less power than the collective, and here how to go ahead. And this is also addressed here in the second paragraph. It's about human dignity, legitimate interest, and fundamental rights. Of course, the data protection principles apply and the data subject rights. So I can stop now because the question is answered, do employees have data protection rights in Europe? Yes, they have. But how to balance these rights and these interests? And in Germany, there have been many approaches. I can tell you for decades, there's ongoing debating on, do we need a specific employee data protection law? And there's an approximation because there's no specific law. There's one very long paragraph in the Federal Data Protection Act, and I show you a little bit, but we won't read it. Still, there are many open questions. Still, there's a lack of legal certainty, especially when it comes to new technologies. And there's much work to do for labor courts. Here you see the very first beginning of the Federal Data Protection Act. In the interest of time, I will skip or skim through the legal text. But you see here, there are many data processing is allowed, but it's only allowed when it's not disproportionate. I think this is the main bottom line here. And you see also the idea of asking for consent. Mind you, we are talking about surveillance at the workplace. Do you agree if I install this surveillance measure, if I do this hidden kind of surveillance? Of course, consent cannot be a basis for that because it cannot be really freely given. Very often it's also not informed, but very often, and I think this is typical for the employer-employee relationship, it's not really freely given. Here are some definitions which may try to, well, show how it's possible under specific circumstances, but that's the exception and not the rule. Okay, what about the staff councils? These are quite well installed in many organizations in Germany. It's not the same tradition in all the states, of course. And it's about the mitigation of the power imbalance because in Germany they are elected by the employees for the representation of their interests. They have to be involved in specific processes, and they should work together with the employer on a trustworthy, on a trusted level. But very often there are, in practice, difficulties. If, for example, a staff council, and they are not necessarily the experts, should understand what is happening with the new software, which also contains some parts of data processing on the employees. Very often it's not well documented. And if it's documented, it's not clear what options there are. For example, can the data processing be minimized? Can it be deactivated at all? Can there be some checks? How can a data protection officer or a staff council check whether the safeguards are in place? And this, I think, is a trend that has become not better but worse, but we need to address that. For some practical solutions, also skimming through that right now only, we believe that escalation strategies are a good thing to go for, because then it's not the maximum surveillance for each cases for everybody, but only if there's a real need to dig into some procedures because there has been wrongdoing, how to find out, how to find the perpetrators, and what about the minimal privacy infringement of the people. And it's not only about escalating, but also about de-escalating. I will upload the presentation if you like to see more on that. It's, I think, the basis to having a workplace climate for loyal, faithful, motivated, productive employees. And then I think it's easy if you also have this staff council or the data protection officers or some other trusted people, if they can be involved in some way in defining the processes, the structures, or sometimes also if you really have to activate those escalation. We are involved in technology for supporting employee data protection. You see here some examples from projects funded by the Federal Ministry for Research, and it's a privacy dashboard thing. We are not involved in this project, I happen to know that, but the other one, the data minimization and software development tools. Do we really need timestamps that are very exact, or can we have more aggregated approaches? This is one of the questions we have here. But both projects demand some changes or offer some additional technology tools to help with that. And I think we need the full picture to have solutions. And perhaps finally, as a practical recommendations, there can be self-audits with checklists or guided questions that everybody knows about, the criteria, the data protection status, the processing measures and the safeguards, and can take this as some guidance and some comparison metrics to see whether you improve or whether there are new topics to be approached. not everything here is translated in English or even Turkish, but some parts are. And so if you need more on that or happen to work on that, please approach me after this Congress. So the current trends, very quickly, I told you already, the pandemics has been a booster for digitization and also a booster for employee monitoring software. If it's right with what the study from the US states, that workplace surveillance is the new normal, this affects standard software on the global market. And I've been told that many criteria where we criticize standard software, and nobody has explained why it's really inside that each keystroke is transmitted to a global player. Then I've been told, yeah, it's because they want that for employee and workplace surveillance in the US. But so I don't want that for my country, my jurisdiction here. And I demand that this is deactivated instead of the new normal. I see also counter trends that are quite hopeful, that at least the sufficient information meanwhile for a data protection impact assessment, which very often has to be conducted, is meanwhile demanded. And I hope very much also that this demand will be fulfilled by the contributors, by the providers in standard software or in specific offers. Also, the debate on digital sovereignty means why should we be dependent from a global market that defines surveillance as a new normal? I think this must not be the case. And open source workplace software strategies, I see some progress there, may offer some parts of the solution, some remedies. But on staff councils and trade unions, even with a long tradition in Germany, with a new economy, with some crowd working platform relationship on who can organize themselves as an employee. This is an open question for me, whether the role will be bigger or perhaps other ways have to be found to mitigate the power balance. So my conclusion is, surveillance at the workplace, do employees have a right to data protection? Of course, should they do. But if we discuss how effective in practice the right to data protection at the workplace is, I have to tell you, we are not there. We have to take a long way, and we have to combine forces to do that. I also have some hope that also the employer side will see that exploitation, only exploitation of human resources is short-sighted, that it's in the interest of the employer to protect the employees and also protect their rights by themselves. And so I repeat myself, let's strive for a workplace climate that fosters loyal, faithful, motivated and productive employees. And this is perhaps a nice hope, but you see this as an example for many discussions we have in data protection, a power imbalance, many roles, many, well, trends that are perhaps counter data protection, but also ways out to really solve it and perhaps have a solution that can be resilient for the future. Thank you very much.
Thank you, Ms. Hansen. Last speaker is Mr. Karadio from Bulgaria. Now it's your turn, and you have 20 minutes, sir.
Thank you. Thank you for the organizers. Do you hear me? Yeah. Thank you very much for the organizers. I would like to thank Professor Kelber and Ms. Hansen for their presentation. As indeed they were able to represent the complexity of the work of the data protection authorities, because privacy actually is very close to all areas of our work. And that's why it is so complex. It's not only the employer that is profiling and is trying to profile the employees, but it's also the technology and that the digitalization world that we want to live right now, and to use this quality of services is also learning from our data in order to provide that quality of the technological service. So for me, it's much easier right now to just explain you the organization of these independent authorities, how they are organized at the European level, because you can you have been demonstrated how they work at local level right now in the member state countries. For that reason, I will use my presentation and it will share it on the screen. Okay. I hope you see it right now. Hello? Do you see the presentation? Okay. In this case, I would accept it for yes. So the European Data Protection Board, as everybody can see right now on the screen, is an independent European body and has its legal personality. It is also composed of the various data protection authorities. Here you can see supervising authorities, and also includes other European bodies as the European Data Protection Supervisor. So eventually from this slide, you may digest that the European Data Protection Board contributes to the consistent application of the data protection rules throughout the European Union, and also promotes cooperation between the European Economic Area data protection authorities, which are members of the board. What is not the board here, and it is very good to understand, is that the board differentiates from the European Data Protection Supervisor, which is a different EU body responsible for the processing of personal data by the European institutions, not only by the institutions, but the bodies and offices of the European Union, for example, like the Europol, Eurojust, the Migration Agency, and etc. And as you can see here, it is established based on different rules, a regulation which is different from the GDPR. And that regulation is giving the competence of this European body, which is different from the European Data Protection Board. The board itself is also not a super regulator or appeal body for the activities done at local level by the data protection authorities. And it can be well demonstrated by the other slides and the video presentation that I have for you. You can hear very well understand how the Secretariat works. It has its members. These are 27 supervisory authorities. And on the right side, you can see the flags of the other other authorities of the European Economic Area, which if we start from the above flag, that is Iceland, Liechtenstein, and Norway, in this way of how they are structured on the right side of the presentation. And the only one EFTA country, that is Switzerland, does not actually participate in the board because it has not accepted the rules of the European Economic Area. They are only member of the Free Trade Association. So these members of the board also are accompanied by the European Data Protection Supervisor and the European Commission as an observer and actively participating in the debates at the Secretariat level. We have here on the left side the Secretariat and the chair position, that is right now our a good well-known colleague, Andrei Jelinek from Austria. And I would like right now to visually explain you what the board is doing and why the board exists by presenting you this slide. Yes, so I think that it was well demonstrated why the board exists and what the capacity the board has and how it works. So you well understood that the board is concentrated on the cross-border cases. There is the capacity, and there the board is providing its interpretation on the consistent application of the rules. And you here have some statistics to demonstrate, in addition to the previous speakers, that on cross-border cases, there's a lot to be done. We have about, let's say, 1,800 cross-border cases this year, and the one-stop procedures that followed of these cross-border cases are quite a lot, more than 800. And about 300 of them already are finalized with the consensus. In two cases, there had been some disagreement between the lead authority and the concerned authorities of the member states about this specific case that led to a discussion and decision by the European Data Protection Board. So the board, in addition, in October 2020, develop a coordinated enforcement framework to facilitate the joint actions in a flexible and coordinated manner, and to launch enforcement sweeps and joint investigations. As you well understood, we as data protection authorities, we have a limited resources and have to use them in the most efficient way. For that reason, there is a pilot project at the European Data Protection Board called Support Pool of Experts, to provide expert support for investigations and enforcement activities of significant common interest. In addition to that, we, as you understand from the video, do quite a lot on developing guidances for the controllers, but also for the controllers and processors, but also these guidances are very useful for the data subjects, for the citizens themselves, to understand what rights they have and how they can implement them. And you see here, there's a lot of work done on developing guidelines on the territorial scope of the implementation of the rules, on the derogations, on certifications, on video surveillance, of course, on the simple related guidance on consent and who is controller, who is processor, and the other complex issues like virtual voice assistants, etc. Because the time is running, I will try to explain you how the board works when we have to adopt a guidance. There are 4 phases here, you can see. First of all, we always try to touch base with the stakeholders and to consult with a wide range of such kind of stakeholders when a specific issue of interpretation of data rights is at stage. We touch base with NGO organizations representing business sectors, think tanks, law enforcement, media, etc. And when this information is collected, the board and its experts develop a draft guidelines for the adoption. They are discussed at the plenary level of the European Data Protection Board as phase 2. And then after there is an agreement between the members of the board, there is a phase 3 that is public consultation via normally the website of the European Data Protection Board, where the concerned bodies provide information about their understanding of the interpretation of the data protection rules of the GDPR provided by the board. And of course, we later on publish this feedback from the stakeholders. After we review the feedback, the guidelines adapted where it is deemed necessary and submitted again to the plenary meeting of the board for final adoption. These are the 4 stages, just for your full information and of understanding of the work of the board. Recently, we developed and adopted our strategy for the next 2 years. Of course, in order to structure our work, it is much more needed than the strategy because the implementation is the key of all these activities listed to you, that is harmonization and facilitating compliance, also supporting effective enforcement and efficient cooperation between the supervising authorities. Of course, we are also care about the fundamental rights approach and the new technologies, and you've heard Professor Kilber and the work of their office there, how significant it is. And of course, the global dimension, indicating the broad picture of how privacy rules are implemented outside Europe and how they act, how they affect EU citizens, is also part of our activities and interest. Being very short, for the next 5 minutes, the first pillar of advancing harmonization and facilitating compliance includes providing guidelines, most generally set, about the data subject rights, about the different principles of processing of the data, like the legitimate interest. And of course, our strategy aims to promote compliance mechanisms for controllers and processors, and where the EDPB invests increase effort and resources to stimulate the development of compliance tools, such as code of conduct and certifications, which are instruments that we did try to promote to the controllers in order to comply with the processing of data of the European citizens. Of course, we work a lot with the professionals so far, and our next stage will be to start developing tools for non-expert professionals, which we see at the small and medium enterprises, and the lack of resources for these controllers to comply with the complicated privacy rules. The other pillar is supporting effective enforcement and efficient cooperation between supervising authorities. This here, I would be very brief, is just want to mention that increasing consistency in enforcement and cooperation between national authorities is indeed the key task of the European Data Protection Board. And that's why here you can see the one-stop shop procedure and the assistance of the EDPB in decisions relating to dispute resolution. These are key for the increased enforcement which the European data protection, the European citizens expect from us as a European body. And of course, the fundamental rights. Why the fundamental rights? It's because privacy is one of the fundamental rights. And whatever tools and mechanisms exist for processing of our personal data exist, they have to comply with the rules. And that's why we do pay attention to the blockchain. We do pay attention for safeguards like anonymization and pseudonymization. And that's why e-privacy regulation is also in the focus of the work of the European Data Protection Board and its members. Of course, in the global dimension, we work to promote high standards for international data transfers, and this can be achieved through various mechanisms. One of them is the adequacy decisions that the GDPR and Law Enforcement Directive allows us to use. And as I mentioned to you previously, the codes of conduct and certification tools for these international transfers. Why? Because European citizens need same level of protection, even though their data is processed by controllers outside of the European Union. The GDPR is a legal mechanism allowing us to control these companies that would like to make profit by using our personal data and delivering services in the European market. And saying that, I would like to thank you very much for allowing me to share that presentation with you and to explain, and to explain the purpose of the data.
Thank you, Mr. Cardio. Thank you to all speakers for these insightful presentations. Now we have 20 minutes coffee break for the second.